Welcome to the stage the first of our combatants, Justin and John. Please come up. Champerty is an agreement between a party suing in a lawsuit and another person who agrees to finance that lawsuit. And, as we all know at common law, this was illegal. But why? Seemingly because society wanted to discourage lawsuits. Today we ask whether times have changed. Our first resolution is third-party litigation financing should be permitted. Our first debate speakers are Justin Brass and John Beisner. Justin, on my right side, is taking the pro side. Until recently, Justin was a managing director at Burford Capital in New York City. I will skip many of the other high notes from his resume and simply start that years and years ago, he graduated from the best LLM bankruptcy program in the nation at St. John's. Judge Warner should be giving me a hug for that. He clerked for Judge Drain in New York thereafter, and he also was an associate at Paul Weiss and elsewhere for a number of years. John, on my left side, is taking the con side. John is a partner with Skadden Arps in Washington, D.C., where he leads its mass torts, insurance, and consumer litigation group. He focuses on the defense of purported class action, mass tort matters, and other complex civil litigation, and over 35 years has defended major U.S. and international corporations in more than 600 purported class actions in federal and state courts. He has also been active in litigation reform initiatives, including before Congress. We thank you both for agreeing to participate today. Justin, we'll ask you to begin today's event with the pro side of the issue.
Great. Thanks, Doug. The best place to start is really what is third-party litigation finance. And third-party litigation finance is a group of funding methods that rely on funds from third parties instead of or in addition to a litigant's own funds. Now, before addressing the benefits of third-party litigation funding and why it should be permissible, Doug hinted at something that comes to everyone's mind when they hear about third-party litigation finance, and that's champerty. In short, champerty is an ancient concept with roots in Greek and Roman law. It was actually put in place in England when the judiciary was weak, so at the time the wealthy were able to take advantage of the court system while the poor couldn't. In the US, courts were skeptical of champerty almost from the beginning. The first criticism of champerty coming in 1824 in New York State Court. And it was for the very reason that I just mentioned, that champerty was put in place when the judiciary was much weaker, and actually the need for it with a strong judiciary was less important. Finally, in addition to that, the reason why the concept of champerty is dated is also looking at how it was used during the Civil Rights era. In the South, many states strengthened their champerty laws after Brown versus Board of Education because of the success of civil rights organizations funding lawsuits to assert their rights under that case. Therefore, in modern times, third-party litigation funding should be permitted as it has many important benefits. A few of the benefits that I would like to highlight and also talk about go to how champerty is also dated is that litigation finance provides those who may not normally have the wherewithal to gain access to the court system or prosecute a claim a way to gain access by tapping the resources of funders who are more familiar with the court process. Second, litigation finance alters the bargaining dynamics between a plaintiff and defendant no matter their financial background. We are very familiar with this in a bankruptcy context. The playing field becomes leveled for the plaintiff without resources and for someone who is already likely out of the money. And instead, they're going to be able to go against a defendant who does have the financial wherewithal to defend themselves and simply stretch the plaintiff thin in order to force an outcome that is more desired by the defendant. Third, by aligning those without sufficient capital to access the court system, the funder allows the litigant to tap into the funder's accumulated expertise in the litigation process. So those without experience in the court process and would otherwise may be intimidated by it or less likely to pursue a valuable litigation will be able to rely on the funder's expertise. There are other benefits to the litigation process, even for those plaintiffs who have the financial ability to bring their own litigation. In many instances, someone who has been spending their own capital in a litigation will want to sanity check themselves to see whether their own behavior is rational. I've experienced this in 2 instances that I think are relevant here. In the first, a well-funded bankruptcy estate in the United Kingdom wanted to obtain funding to take a matter through trial. The case had already been pending for years, and trial was only a month away. But after prodding from a member of the liquidation committee, the liquidator was forced to seek funding to mainly gain the reaction. Funding was denied due to our analysis that there was troubling precedent that was directly on point. And while the facts of this new case were attractive, it was going to be hard to overcome that precedent. So the liquidator, having already spent years involved in the case and millions of dollars, decided to proceed anyway. The liquidator ended up losing at trial. This is a great example where had the liquidator come to a rational economic actor or a disinterested party first, they may have saved the estate millions of dollars in legal fees. The second example that shows the benefit of third-party litigation funding where a plaintiff does have resources is where a wealthy businessman wanted to sue the private equity sponsor who purchased his business. After spending a small fortune with his counsel, he sought funding to sanity check himself and get insight to whether this was simply a personal dispute for him and not something that a rational business person would do. Again, in that instance, funding was declined. Taking that even one step further into the world of Chapter 7 trustees, there have been recent articles that have highlighted how the Chapter 7 trustee in MagCorp used litigation funding in order to hedge some of his appellate risk in a case that had been pending over a decade. In MagCorp, the Chapter 7 trustee determined that it made sense to obtain cash today instead of risking getting nothing if he were to lose before the Second Circuit Court of Appeals. The trustee hedged that risk by auctioning off a capped interest in the eventual proceeds. In addition, the trustee was on record noting that in the event the case was remanded, he actually had very little resources in order to pursue the case. And on the flip side of that, if he lost, he would still have capital to pursue it. These examples of a disinterested commercial actor coming in to assess the merits of litigation in an effort to determine whether to invest provides valuable insights into litigation. It's litigation that's beneficial to plaintiffs whether they have access to capital or do not. Leveling the playing field, providing a sounding board, all of this for a party about to embark on time-consuming and expensive litigation is a valuable tool and shows why third-party litigation finance should be permissible.
Thank you, Justin. John?
Thank you. I want to start by clarifying a bit the definition of third-party litigation finance. Justin, I think, has it right, but I do want to stress the fact that what we're talking about here is an investor buying an interest in the outcome of the litigation. We're not talking about loans, anything like that. We're actually talking about an investor who, in a way, becomes a real party in interest in the matter. TPLF takes many forms. To my mind, some are of greater concern than others. But as Justin said, the main justification has been access to justice. But is there really a need for more litigation in the U.S. judicial system? Unlike most legal systems, the U.S. already permits contingency fee arrangements. You don't find those in many other legal systems around the world. Unlike most legal systems, the U.S. also has no loser pays doctrine. In most other locations, if you sue and you lose, you're obliged to pay something to the other side. And so the main concern I have about TPLF is that it encourages marginal litigation claims. If you pour millions of dollars and make them available to launch more litigation, that's going to happen, and the bar on when an attorney decides to launch a case is going to be lower. I won't stand here and take the position that all forms of TPLF should be prohibited, but I think it should be disclosed in all cases. And so really the issue for me is, should TPLF be permitted in secret? Why do I say disclosure is necessary? Well, for one, as Justin was mentioning earlier, one reason you need to know is whether the arrangement is legal. He referenced champerty doctrines. There has been a lot of debate in the courts about the vitality of champerty in recent years, but I would note that in the last 3 months alone, there have been 3 state appellate courts that have nullified third-party litigation finance agreements on champerty grounds. The doctrine is alive. And I would add to the justification for it what I'm just talking about. Part of the reason for this is because if you get sued by somebody, you ought to know who's suing you. You ought to know who the real party in interest is, who is going to benefit from the litigation if they prevail. Then there's the question of whether the terms of third-party litigation arrangement allow the funder to improperly take control of the litigation, to take it away from the real party in interest. A good illustration is a recent bankruptcy court decision out of the Western District of North Carolina, the In Re Design Line Corporation case. In that case, the main assets of the debtor were unasserted causes of action. The trustee proposed to sell interests in those causes of action to a third-party funder in order to finance the litigation. Initially, the trustee tried to keep those arrangements secret, but the court insisted that they be disclosed. When they were revealed, those arrangements were challenged on the ground that they violated North Carolina state law because the funder would wrest substantial control of the litigation away from the trustee. The bankruptcy court agreed, placing great emphasis on the fact that the funder had the power to cut off the funding if it didn't like the way the case was going. And so, in part based on North Carolina champerty principles, the fact that control would be assumed by the funder, those arrangements were rejected by the court. There are other reasons to have disclosure. The court needs to know if it has a conflict of interest with the funder. Many of the funders are publicly traded, so the courts need to know if they have a conflict of interest. You also need to know if the funder is present, because if there are problems in the case that result in sanctions, the funder is a real party in interest that ought to be subject to that. Also, in civil litigation, we now have the notion of proportionality in the discovery process. It looks at the wherewithal of a party to pay for its own discovery. Well, you need to know if you have a major funder out there that's contributing to the effort. There are also special issues in some cases, particularly class actions and aggregate litigation where I practice. Indeed, the Northern District of California, the U.S. District Court there, recently adopted a standing order that requires disclosure, at least in class actions and aggregate litigation. It was based in part on a case that occurred out there where it was discovered that the attorney for a proposed class had agreed with the funder to give some of its attorney's fees over to the funder in order to get investment in the litigation. Well, there's a problem with that. Attorneys can't give fees to non-lawyers. It's an ethical problem. And more importantly, the funder, as part of the agreement, got 2% of the benefits that were to be provided to the class members without telling the class members that some of their potential recovery had been assigned. So I think that the fundamental position that I would like to articulate here is, yes, maybe it should be permitted in some circumstances, but third-party litigation funding should not be permitted to exist in secret.
Thank you, John. Justin, your rebuttal?
Great. So to address a couple of those points, let's just start with the control and the notion of control. And I'm going to go a little bit more narrow in terms of how it really applies in the bankruptcy context and why within bankruptcy people should be more comfortable with control if it happens to exist in a litigation funding agreement. The reason is, let's look at DIP financing as an example. There are many instances where cases file, and on the first day a DIP is approved, where a business has to be sold in some fixed duration, and at times, as we've all seen, especially in some of the retail cases, that time period is becoming shorter and shorter, and the DIP lender is obtaining more control, whether it's a milestone as to when a plan must be filed, a milestone for a disclosure statement, and all of those things deal with control of actually the entire case. In terms of litigation funding, we're talking about control over one particular asset and the direction of that asset, and having input on the direction of that asset from someone who is skilled in dealing with that. So I think that's, first of all, where a court can take comfort in comparing litigation finance to other forms of bankruptcy finance, which also ties right into disclosure. And I understand John's point regarding the Northern District of California and the rule as it relates to class action. Class action, I think right now, the bankruptcy code has its own requirements that would require disclosure during the course of a case. In the course of a case, we have requirements in 363 saying if an asset's going to be used outside the ordinary course of business, you need to go to the court for approval. So I think that we already have that system in place, and then to the extent it's post the effective date, you default to whatever the standard rules may be, and which makes sense because there's no reason defendants should know the extent of a war chest that exists on behalf of the litigation trust. Finally, just one more point on John's mention of the loser pays. I'm in full support of the federal rules adopting some of the more stringent offer of judgment statutes that exist at the state level. If you look at Florida, for example, their offer of judgment statute would allow a defendant in a litigation that's deemed worthless to file an offer of judgment and then obtain attorney's fees and costs in certain instances.
Just a few quick points. On the control issue, I'm not saying that in all instances, whatever the third-party funder obtains in terms of the contractual arrangement is necessarily bad, but as in the bankruptcy case that I mentioned earlier, it should be disclosed so the court can make that decision. I'm sympathetic to what Justin is saying about disclosing information about the funding arrangement that may give one side or the other a strategic advantage. And it's interesting, in that bankruptcy case I cited, the court said everyone gets to see the agreement, but I'm not going to require that you produce the memos and so on about the litigation strategy. We just need to have an understanding of what the control arrangement was. And that's no different in civil litigation. That happens on both sides. A defendant has to put out under the federal rules whatever insurance it has available to finance the litigation. It has to make disclosures and SEC filings about any reserves that it's taken for the litigation, about the existence of the litigation, what it's spending on the litigation. And so to have some disclosure about the third-party litigation finance arrangement to allow the court to take a look at it to make sure that it's consistent with ethics rules and other requirements is appropriate.
Thank you, John. Thank you, Justin. Okay, now it's time to vote. Go to ABI poll, go to poll.abi.org, poll.abi.org. Doing things a little bit differently this time. We're going to take a quick test question, which we'd appreciate you voting on. Bankruptcy filings in 2017 will rise, we hope. A, B, C, D, and E is no opinion.
This is going to be 100% A.
Okay, less than 10% sounds like it has the winning answer, B. Okay, now that you're all ready to vote on the real issue at hand, the resolution is third-party litigation financing should be permitted. Agree strongly, Agree somewhat? John, you have the wrong audience here. That's the, we all need money to finance litigation and
Here we
keep us
go.
working.
All right.
Is that it? Thank you very much. Thanks, John. Great job.